Association of Trinidad and Tobago and the Honourable Chief Justice.
Yes, Mr. Hicks.
May it please your Ladyship, may it please the Lords. I've got 4 brief introductory remarks. Firstly, I hope you all have details of the party's representation, so can I take that as read?
Yes, please.
Thank you. Secondly, my lady, thank you for expediting this appeal. Thirdly, I propose to address the issues which arise under Section 137 of the Constitution and Section 5 of the Legal Profession Act, that's the vires issues. And then Mr. Benjamin, who presented all the oral argument in the courts below, who sits beside me, is going to address you more briefly on the issues as to natural justice and apparent bias.
Fairness and bias, yes.
And then my final introductory remark is this. I propose to take the statement of facts and issues and at the very least the parties' written cases as read. And so without further ado, I propose to proceed to my submissions on the issues raised in the appeal.
That's very wise.
It is, we suggest, obviously essential at the outset to understand the nature and the purpose of the respondent's investigation before one can sensibly assess whether that investigation is in breach of Section 137 of the Constitution or indeed ultra vires the respondent's powers under the LPA. So can I very briefly take you to the evidence as to the purpose and the nature and purpose of their investigation with a few, and I promise only a few, references from the evidence. Can I ask you to turn up Record of Proceedings Volume 2 at page 624 of the electronic bundle. This was the respondent's report of its council meeting on the 29th of November of last year, addressed to the members of the Respondent Association. This is to report that on 29th November, the Council of the Law Association met to consider recent newspaper reports in which certain allegations were made against the Chief Justice. After due deliberation, the Council decided as follows. 1, that the allegations made were sufficiently grave to warrant further consideration by Council as to what appropriate action it should take. 2, that a committee be established to attempt to ascertain, substantiate the facts upon which the allegations made against the Chief Justice were alleged to be based, and to report back to the Council for further consideration. What happened next was that on the following day, the 30th of November, the respondent's president, Mr. Douglas Mendes, senior counsel, and a senior ordinary member, Mr. Elton Prescott, senior counsel, met the Chief Justice and explained to him various things about the investigation. And what they told him was then set out in an email sent to the respondent's members on the 18th of December of last year, and that's in the same bundle, the email that is, at pages 626 to 627. No, 627 to 628. Dear members, further to a previous email informing you of decisions of Council in relation to certain allegations made against the Chief Justice, the Council of the Law Association advises the membership further of the following matters. 1, on November 30th, 2017, as mandated by the Council, the President of the Law Association, Mr. Douglas Mendes, and Senior Ordinary Member, Mr. Elton Prescott, met with the Chief Justice. Mr. Mendes, at the meeting, Mr. Mendes and Mr. Prescott informed the Chief Justice of the following. A, that the Law Association considers that it has a dual role to play, on the one hand to protect the judiciary from unfounded allegations, and on the other to hold the judiciary accountable for its actions. 2, that the Law Association has taken note of allegations made against him in the Express newspapers. C, that the allegations made against him are serious and are considered by the Law Association to be serious. D, that this is a view shared by many members of the Law Association and other members of civil society. E, that there have been cause for his resignation having regard to his failure to respond to the allegations. F, that his failure to respond has most likely led members of society to conclude there is some truth to the allegations. G, that the gravity of the allegations and his failure to respond have brought the office of Chief Justice into disrepute, and by extension the entire judiciary. And then H, this, that the Council of the Law Association has resolved to investigate the allegations to determine whether they are true or not. And then at the conclusion of the meeting, the Chief Justice said he would think about the representations made to him. And then 4, in passing, can you note, upon receiving such advice, that's the advice of 2 senior counsel referred to in 3, Council will convene a meeting of the general membership to consider such advice and obtain directions as to the way forward.
Mr. Havers, you skipped 3. We might just read that.
Yes, of course. Council has resolved to retain 2 senior counsel to advise on the question whether there is sufficient basis to refer a question of misbehaviour by the Chief Justice to the Prime Minister for his consideration pursuant to Section 137 of the Constitution.
Thank you.
Now, my lady and my lords, lest it be suggested that there was any doubt about the contents of that email, in particular the reference in the email to the purpose of the investigation being to determine whether the facts were true or not, the President himself swore an affidavit in these proceedings, which I'd like to show you. It's in the same bundle, Bundle 2, beginning at page 500, or the reference I want to draw your attention to is beginning at page 589. The affidavit itself begins at page 587, and at page 589, paragraph 13, Mr. Mendes refers to the meeting he had with the appellant on the 30th of November. Picking it up 2 lines from the bottom of that page, we inter alia informed the Chief Justice of the Council's concerns made against him about allegations made against him in the press, and his failure to respond to those allegations, and of our decision to establish the committee to ascertain / substantiate the facts which form the basis of those allegations. The Council informed the membership of the Law Association of the meeting with the Chief Justice on the 30th of November 2017, and in brief what had transpired by an email dated the 18th December 2017. That's the email I've just shown you, and he goes on, the contents of which are true and correct. Can I then take you to Bundle 1 of the Record of Proceedings, page 50. This is a report in the Guardian newspaper on the 18th of December of last year, and in the right-hand column you will see a piece headed Law Body Adopts Cautious Approach. The Law Association says it will await the outcome of the work of a committee set up last week to look into and verify, I stress those words, allegations made against the Chief Justice before it decides on the next course of action. Speaking to The Guardian yesterday, President of the Association, Douglas Mendes, says as part of its work to verify the allegations made against the Chief Justice, quote, will be speaking to those who it appears from the newspapers may know something, close quote. In the same bundle, can I take you next to page 58? And I should have added that there was nothing in the affidavit that I took you to a moment ago from Mr. Mendes to suggest that he'd been misreported or misquoted in that article. So page 58, a letter to the Chief Justice from the respondent dated the 20th of January of this year. As you are aware, the Council of the Law Association has established a committee to attempt to ascertain / establish the basis of certain allegations made against you in the Express newspapers. Can I then pick it up in the next paragraph? The Law Association has embarked upon this exercise against the backdrop of what appeared to be serious allegations, your failure for quite some time and then only briefly to answer the allegations, and the Prime Minister's publicly stated position of non-involvement. The Law Association considers its duty to protect you against these allegations if they are not substantiated, or to hold you accountable if they are. And then the third paragraph, the purpose of this letter is to inform you of the matters which the committee considers to be of sufficient weight and sufficiently established at this stage, and to give you the opportunity to provide any information or give any response which you may choose to give. And then the Council fully appreciates that it has no power to compel you to respond, and that it has no disciplinary or other power in relation to you. We do consider, however, that as with any other citizen, we have the power to refer a complaint to the Prime Minister for him to treat with as he deems fit. And we are satisfied that the power to refer such a complaint falls within our statutory mandate. And then finally, in the same bundle, page 87, you will see the notice of a special general meeting of the Respondent Association, dated 26th of February this year, addressed to all members of the association. The Council hereby calls a special general meeting to take place on Thursday, 15 March. The objects of the meeting are as follows: to consider the report of the committee appointed to ascertain, substantiate the allegations, to consider the advice of Dr. Alexis and Mr. Courtney, and to direct the Council as to the course of action to be taken, if any. So we respectfully submit that what the evidence shows is that, first, the purpose of the investigation was to determine whether the allegations were true or not. Secondly, if the investigation found that they were, the respondent would hold the Chief Justice accountable.
What do you say that means?
Well, it's very difficult to know what that means, but it must mean more, we suggest, than simply referring the complaint to the Prime Minister.
Well, what else can they do? I mean, it can't mean that they propose to take steps which they have no legal power to take.
I respectfully agree. One thing it could mean is that the Council would do what it did last year in relation to a completely separate matter, and that was to pass a motion of no confidence in the Chief Justice and call on him to resign. So it could well mean that.
Well, there's no reason why they shouldn't do that, is there?
My Lord, no, there's no reason why they shouldn't do that, my Lord. But they did that last year. Whether that's an appropriate thing for them to be doing in the context of an investigation into these allegations is a matter I'll come on to later. But they haven't indicated what they meant by accountable, but that, I suggest, is one of the things that they may have had in mind. And then thirdly, and this picks up my Lord Assumption's question to me, after taking legal advice, the respondent proposed to hold a general meeting of its members to determine the way forward, to consider what steps should be taken next. And as I've said, one possible step would be the one I've referred to. My Lords, and my Lady, it's clear in our submission that the Court of Appeal understood the purpose of the investigation in the same way. Can I just invite you to turn up volume 3 of the record of proceedings and go first to page 1017. Which is in the judgment of the acting Chief Justice, Justice of Appeal Mendonça, and at paragraph 12 on page 1017, following and continuing on to page 1018, you will see that he sets out the email that I took you to a few moments ago in full, without any suggestion that the respondent had indicated that the email was in any way untrue or incorrect. Can I then go to the judgment of Justice of Appeal Bevero, beginning at page 1098. Paragraph 26, where, as we see from the opening sentence, he is addressing the kind of inquiry contemplated by the respondent. And 4 lines from the end of the paragraph, you will see he says, "There's no consequence to the Chief Justice's tenure if an adverse finding is made." And then he uses a similar expression in paragraph 27. Mr. Benjamin raises valid concerns. A non-section 137 inquiry which reaches adverse conclusions against a judge or Chief Justice. And we suggest that they can only be references to findings that the allegations were true. And then at page 1108, in the context of his 1108 of the same bundle, in the context of the Justice of Appeal considering the Varies argument, second line at the top of the page, in my judgment, the LATT does have the power to investigate and establish the facts in relation to the allegations against the Chief Justice. And then he picks that up again at the foot of the page in paragraph 47, 3 lines from the end of the page. If the allegations are false, as the respondent contends, then why stop the inquiry? Let the true facts emerge. So his understanding must have been, we suggest, that the investigation was to determine whether the allegations were true or not. And then Justice of Appeal Jamadar at page 1124, paragraph 14, he says about 5 lines into the paragraph, yet there's been no clear resolution as to the truth or falsity, credibility or otherwise, in relation to any of these allegations. And then 1127, where the position is even clearer, paragraph 20, halfway through the paragraph, again, what is clear is that the LAT's intention, as formally communicated to the Chief Justice on the 30th November 2017 and undenied on the evidence, was to conduct an open-ended investigation into the factual underpinnings of the allegations made against him in order to ascertain whether they were true or not. In furtherance, and to do so in furtherance of its assumed role to protect and or to hold the judiciary accountable for its actions. And then lastly, at 1130, at the foot of the page before the footnotes, paragraph 27, determining whether these serious allegations against the Chief Justice are true or not is therefore to the best interests of the legal profession and so on. So in his case, it couldn't be clearer that he understood the purpose of the investigation to be to determine whether the allegations were true or not. As to how far the investigation has got, all we know is that, as we understand it, the investigating committee has prepared an interim report which it has sent to the Respondents' Council. But more than that, we do not know. We don't know whether the Council have interviewed witnesses. We don't know whether they've taken witness statements from witnesses, which would raise concerns if they had done so, which I'll come to later. We don't know if legal advice has yet been taken. We don't know whether the final report has been prepared. What we do know, however, is that the respondent now appears to be saying in its written case that it has done no more than to inquire into the facts sufficiently to decide whether there is a proper basis to refer the allegations to the Prime Minister, that it does not intend, this is what it appears to be saying, to determine whether the facts and the allegations are in fact true, and that it didn't intend to do so even at the outset. And your Lordships and my Lady would have seen the many paragraphs in the respondent's written case where it gives that indication. The difficulty we submit that the respondent has is, first, that that's not what the evidence that I showed you a few moments ago shows. Secondly, it's not what the President told the Chief Justice when he went to see him on the 30th of November last year. It's not what the respondent told its membership in that email that I showed you, which was addressed to all the members of the respondent. There is no evidence to that effect. The President of the respondent swore an affidavit saying that the contents of the email were correct and true. And even the respondent's written case begs a number of important questions. And can I invite you to pick up the respondent's case and to go to paragraph 57, which is at page 1297. Where we find this: the Law Association maintains as a fair summary that the investigation is to ascertain or substantiate the facts upon which the allegations are alleged to be based. Pausing there, that sounds very like the original statement of the purpose of the investigation, which we discovered when we looked at the email, meant in fact to determine whether the allegations were true or not. The investigation may well involve the Law Association forming, at least on a preliminary basis, a view about the conduct of the Chief Justice. The Association submits that the true scope and nature of its investigation has been made clear. This is beyond doubt in light of the clear and consistent explanations given in both courts below. Insofar as clarification is needed, the Law Association does not intend to finally pronounce on whether the allegations are true, which begs the question, do they, however, intend to make some provisional pronouncement on whether the allegations are true or not? And then paragraph 57 goes on, but it does not consider its investigation to be constitutionally limited to establishing the barest of facts or evidence necessary to make out a prima facie case. Neither does the Law Association consider the proposed test of proper basis or prima facie case to be useful or appropriate tests for delineating the constitutional limits of its investigation, which again raises the question, does the respondent in fact intend to go further than that and to set about investigating whether and determining whether the allegations are true or not? And then this, in the end, the association must be free to inform itself best as it can of the underlying facts before getting legal advice and taking any action, and that is what it has sought to do. And again, the reference to informing itself best as it can of the underlying facts sounds, we suggest, like a fact-finding exercise. So, my lords and my lady, the respondent appears still to be contending that it would be entitled to carry out an investigation into the truth of the allegations. And of course, the question remains as to what its powers are and what it is properly able to do under Section 137 in the event that any allegations are raised in the future about another judge. So the question is of real importance, even apart from the obvious lack of clarity as to what the respondent has done so far and what the respondent intends to do in the future by way of this investigation. And thus I propose to make submissions addressed to the question whether the respondent can lawfully carry out an investigation to determine whether these allegations against this judge, or indeed allegations against another judge, are true or not. And ultimately, can I then go to the Constitution and address directly the first issue which arises under section 137. You will find the Constitution in the first bundle of authorities at page 1332. And can I ask you to go first to section 2, which is at page 1344. And I know that some of the court will have seen this Constitution before in other cases, so some of you may already be familiar with it. So section 2, this Constitution, and can I just say that the Constitution of Trinidad and Tobago is very similar to the Constitution of many other, if not most other, Caribbean countries, in terms of following the Westminster model and in terms of the provisions it makes in particular as to the independence of the judiciary. So section 2, this Constitution is the supreme law of Trinidad and Tobago, and any other law that is inconsistent with this Constitution is void to the extent of the inconsistency. Section 4, beginning at 1348, sets out enshrined rights or entrenched rights, which you will see over the page include 2 that are relied upon by the respondent: little I, freedom of thought and expression, and little k, freedom of the press. Section 5 provides for the entrenchment of Section 4, except as is otherwise expressly provided in this chapter, and in Section 54, no law may abrogate, abridge, or infringe, or authorise the abrogation, abridgment, or infringement of any of the rights and freedoms hereinbefore recognised and declared. And it may be convenient just to pick up Section 54 at this point, page 1384. And it provides for a majority of at least 2/3 of all members of the House voting in favour of any provision that would amend in any way the entrenched provisions that you've seen in Section 4. Going back, if I may, to Section 13, which begins at the foot of page 1354. And this is acts inconsistent with Section 4 and 5. An act to which this section applies may expressly declare that it shall have effect even though inconsistent with Section 4 and 5. And if any such act does so declare, it shall have effect accordingly, unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individuals. Then subsection 2 provides for a 3/5 majority required for the passing of any such provision. Section 14 provides for the general right of redress under the Constitution. And then I go to section 137, which begins at page 1441. Subsection 1, a judge may be removed from office only for inability to perform the functions of his office or for misbehaviour, and shall not be so removed except in accordance with the provisions of this section. 2, a judge shall be removed from office by the President where the question of removal of that judge has been referred by the President to the Judicial Committee, and the Judicial Committee has advised the President that the judge ought to be removed from office for such inability or for misbehaviour. 3, where the Prime Minister, in the case of the Chief Justice, or the Judicial and Legal Service Commission, in the case of a judge other than the Chief Justice, represents to the President that the question of removing a judge under this section ought to be investigated, then A, the President shall appoint a tribunal which shall consist of a chairman and not less than 2 other members selected by the President acting in accordance with the advice of the Prime Minister in the case of the Chief Justice, or the Prime Minister after consultation with the Judicial and Legal Service Commission in the case of a judge, from among persons who hold or have held office as a judge of a court having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or a court having jurisdiction in appeals from any such court. B, the tribunal shall inquire into the matter and report on the facts thereof to the President, and recommend to the President whether he should refer the question of removal of that judge from office to the Judicial Committee. And C, where the tribunal so recommends, the President shall refer the question accordingly. Subsection 4 is concerned with suspending a judge in the meantime, but that doesn't arise in the present case. So, pulling all that together, if the Prime Minister, in the case of the Chief Justice, as in the present case, represents to the President that the question of removing a judge ought to be investigated, the procedure under Section 137, as you can see, is first, the President appoints a tribunal. Secondly, the tribunal is to consist of a chairman and not less than 2 other members selected by the President. Thirdly, the members of the tribunal essentially are to be senior judges, if I can summarize the detail of what is provided. 4, the tribunal then inquires into the matter. 5, the tribunal then reports on the facts to the President and recommends to the President whether he should refer the question of removal of the judge to the Judicial Committee. 6, if the tribunal so recommends, the President must refer the question to the Judicial Committee, and the Judicial Committee then decides that question. And if it decides that the judge should be removed, the President must do so. We stress that under Section 137, as you can see, the fact-finding role, the role of determining whether the allegations in question are true or not, is expressly to be carried out by the tribunal appointed by the President, a tribunal to be made up of current or former senior judges. And as to what that might mean in practice, can I take your Lordships and my Lady briefly to the Chief Justice of Gibraltar case, which is in Bundle 4 of the authorities, behind tab 36, page 2633. As you can see from the head note, all the Queen's Counsel in Gibraltar, save for the Speaker of the House of Assembly, signed a memorandum to the Governor expressing deep concern at the state of affairs, which had developed seriously affecting the administration of justice and the reputational image of Gibraltar, and stated they'd lost confidence in the ability of the Chief Justice to discharge the functions of the office. Picking it up at little h, you will see that a tribunal of 3 senior judges sat to hear evidence of fact and then made a report. Can I take you to page 2639 first, where you will see, beginning just below letter C, the relevant Gibraltar Constitution Order of 2006, which was broadly similar to Section 137. If you pick it up at Section 4 or paragraph 4 of the order, just letter G, if the Governor considers that the question of removing the Chief Justice from office for inability as aforesaid or for misbehaviour ought to be investigated, then the Governor shall appoint a tribunal. The tribunal shall inquire into the matter and report on the facts to the Governor and advise the Governor whether he should request that the question of the removal of the judge should be referred to the Judicial Committee. If you go over the page to 2640, at just below letter E, paragraph 6 of the judgment of Lord Phillips, you will see that the constitution of the tribunal, 3 very distinguished former senior judges. And then at paragraph 8 towards the foot of the page, you will see the procedure that was adopted, They sat to hear evidence of fact. 18 witnesses gave oral evidence. They also had regard to written statements by a further 11 witnesses who didn't give oral evidence. And then over the page at letter B, you will see what the tribunal then did. It sent its report to the governor. The report made findings of primary fact in relation to each of the 23 episodes identified in the statements of issues. And so that's the procedure that Section 137 involves. And we submit there are good reasons why that is the appropriate procedure for finding facts in relation to allegations of misconduct against a judge and in determining whether those allegations are true. Firstly, because such serious and sensitive allegations will, under the Section 137 procedure, and ought to be determined, we say, by senior judges who will be able to bring their experience and expertise to such a sensitive and likely very important task. Secondly, the tribunal under Section 137 can be relied upon to ensure procedural fairness, something which the respondent, in relation to its investigation, says it's under no obligation to provide. And thirdly, all this is, we suggest, plainly of vital importance given the context of such an investigation, namely the independence of the judiciary and the potential loss of office or removal from office of a judge. In other words, it's essential that if there is to be a formal investigation to determine whether such allegations are true or not, that investigation is carried out in accordance with the Section 137 procedure. So we submit as follows. First, Section 137 provides the sole and exclusive procedure for formally determining whether the facts and allegations are true, and whether, in the light of those conclusions on that, whether consideration should be given to the judge's removal. Secondly, Section 137 is prescriptive as to who should carry out that task, when and by what process. And thirdly, if the framers of the Constitution had intended that some other body or person should be entitled to do so, then they would have said so in the Constitution.
Was it in your submission unconstitutional for the newspapers to conduct whatever investigations they did conduct before publishing their articles?
No, my Lord, it wasn't. And I'm going to come on to explaining to the board why we draw a distinction between investigations carried out by the press, or indeed by a member of the public on the one hand, and the investigation which this body indicated at the outset it proposed to carry out on the other hand.
And does it follow from your submission that the second memorandum in the Chief Justice of Gibraltar case, in which the Queen's Counsel of Gibraltar set out their understanding of the facts which justified their loss of confidence, was unconstitutional or contrary?
No, my Lord. We accept that the respondent can inquire into allegations against a judge sufficiently to enable it to decide whether there is a sound basis for making a complaint to the Prime Minister under Section 137. That's what the QCs in the Gibraltar case did, and it's what, as we'll see when we come to it, the Belize Bar Association did in the Mirabux case. But in neither case did the relevant QCs or the Belize Bar Association go any further than that, let alone set up an investigation to determine whether the allegations were true or not. And it was never suggested either by those respective lawyers on the one hand or the courts on the other hand, which heard those cases, that they had any power to do so. in fact, I see that the next point I was going to make was that we accept that, like anyone else, the respondent may make a complaint to the Prime Minister and invite him to invoke the Section 137 procedure, and that the respondent may inquire into the facts in order to satisfy itself that there is a proper basis for making a complaint. But there is, we submit, all the difference in the world between doing that on the one hand and setting up an investigation to determine whether the allegations are true or not on the other hand. Can I show you the Belize, the other case where a complaint was made by the local lawyers? That's to say that the Belize case, it comes in at two stages. What had happened is that, can we turn it up? It's initially before the Chief Justice of Belize. It's at volume 3, tab 30, page 2345. And if I can just, in a paragraph, summarise the facts without needing to take your lordships and my lady through the facts in any detail. The Governor-General of Belize decided that allegations of misbehaviour which had been made against a judge by the Belize, a judge of the Supreme Court by the Belize Bar Association, should be investigated. And he had therefore referred the matter to the Belize Advisory Council for the council sitting as a tribunal to report on the facts and advise him whether the judge should be removed from office. So the procedure was broadly the same as the procedure under Section 137, save that the Governor-General was in overall charge of the process. The judge then decided that at the stage when the Governor-General has to consider whether the matter should be referred to the Advisory Council, the rules of natural justice apply, and the judge should therefore at least have notified the judge of the allegations and given him an opportunity to respond to them. However, if I can take you to page 2363 in the bundle, just over halfway down the page, you'll see a paragraph that begins, "The applicant in this application also contends that there's a duty on the Governor-General to investigate the validity of the allegations being levelled against him before sending them to the Belize Advisory Council." And we find the judge's ruling on that beginning at the foot of page 2366. In the light of all these considerations, I am unable to hold that the applicant is entitled to the declaration that he has been deprived of the protection of the law because the Governor-General has not investigated the validity of the allegations against him, which may form the basis for consideration by the Belize Advisory Council of the question of removal. It is not for the Governor-General to investigate the validity of the allegations. This is a task by the provisions of the Constitution for the Belize Advisory Council. Now, that case then found itself to this court, following the judge having been removed from office by the Governor-General, following a hearing before the Advisory Council sitting as a tribunal. And the report of the judgment of the board in this court is behind tab 31 in the same bundle, page 2374. And if you would be good enough to go to page 2375, paragraph 2, you will see that what the appellant's case before the board was. Essentially, bias and, essentially bias for one reason or another. But can I just invite you on your way to the paragraph I want to show you towards the end of the report, just to note paragraph 5, where you will see details of the procedure to be followed at the hearing before the tribunal. About halfway through paragraph 5, he was told that the complainants would have the right to retain the service of counsel to conduct the proceedings. He was to have the right to retain counsel to represent him, proceedings and notes of evidence to be recorded verbatim, witnesses to give their evidence, and so on. So a quintessentially fair procedure was to be followed. And you will see at paragraph 9, 2378, the tribunal proceeded with its inquiry, and then over the page at paragraph 11, it prepared its report and in which it set out its findings, the section 237 equivalent procedure. And then can I take you to paragraph 28 at the top of page 2388. And pick it up in the second sentence, about 6 lines down. Section 43 of the Legal Profession Act provides that the objects of the Bar Association include representing the bar in matters concerning the profession in relation to the courts and promoting the proper administration of justice. Paragraphs D and E, and that summary, that unfortunately D and E aren't set out verbatim in the report, but that looks very like section 5 little f of the Legal Profession Act, which I'll come to a little later. So it must also have been appreciated that complaints alleging inability or misbehaviour on the part of a justice of the Supreme Court would be a matter of concern to the Bar Association, and that it would be likely to be involved in the presentation of such complaints to any tribunal that was convened to inquire into the matter under then the reference to the relevant statutory provision in Baileys. But no suggestion, whether by way of submission on the part of the Belize Bar Association or by way of finding on the part of the board, that the complainants, in that case the Belize Bar Association, had any entitlement to go any further than to present a complaint to the Governor-General, let alone to investigate whether the complaint or the allegation was true or not. My Lords and my Lady, I should add that we don't submit, and I've made this point in answer to my Lord assumption already, that the media or indeed any member of the public would be prohibited by section 137 from inquiring into allegations of misconduct against a judge beyond the stage of whether deciding whether there's some proper basis for making a complaint to the Prime Minister. So there's no question of us suggesting that there should be any restrictions on free speech or freedom of the press, nor is there any question of judges becoming immune from public scrutiny, as it is suggested in the respondent's written case we are effectively submitting. What we submit is that this respondent cannot lawfully carry out a formal investigation to determine whether these allegations are true or not. And can I then try to explain the distinction that we draw? Essentially, we submit that there is all the difference in the world between the respondent's investigation on the one hand and an investigation or inquiry by the media or an individual member of the public on the other hand. First, the respondent is a public authority created by statute with specific powers and duties. Secondly, the respondent claims for itself a special legal or constitutional power, indeed obligation, to carry out its investigation, whereas the public are very unlikely to think that the media or an individual member of the public has any such role or obligation. Thirdly, the respondent's investigation is a formal affair, It will decide whether the allegations are true. It will then take legal advice, and it then proposes to call a meeting of its members to decide what to do. No such formality is attached to an investigation by the media or individual members of the public. Fourth, the respondent's investigation proposes to find facts, that is to say, reach objective conclusions about whether the allegations are true or not, whereas at most an investigation by the media or an individual will be able to express a subjective view of the facts.
I don't think I understand why you're drawing that distinction.
Well, because the respondent's investigation will purport to find facts. If its purpose is to determine whether the facts and the allegations are true or not, it will be engaged in a fact-finding exercise, presumably objectively arrived at in terms of finding the facts.
Yes.
Whereas the media and individual members of the public, the sort of investigation they carry out is very rarely said to involve objective fact-finding on their part.
Some of the reports assert facts, do they not?
They assert facts, my lord, yes. I readily accept that, but not as a result of the sort of formal investigation that the respondent is carrying out.
But the assertion of facts must or should be preceded by a finding of facts on the part of the author.
Well, nor should be. I mean, the media will carry out an investigation.
Well, there's nothing to inhibit the media finding facts and then reporting them as assertions.
No, I readily accept that.
If they'd had an editorial which said that we have patiently examined the evidence for the past 3 weeks, taken legal advice, consulted experts, and we have come to the conclusion that the following facts are established, that would be contrary, would it, to what Section 137?
Well, it would be getting pretty close to it, yes. Your Lordship's question presupposes that the editorial would ever, in fact, say so. I can't recall ever having seen it.
It's a purely hypothetical.
Yes, my lord.
I just want to see quite how far this
I understand.
This submission goes.
I understand. But the submission is, I hope, rooted in reality, the reality being that press inquiries and investigations are in truth very different to the sort of formal fact-finding investigation that the respondent is, so far as we know, still carrying out or has already carried out.
Well, if we're going to, talking about reality is perhaps rather dangerous ground for you. I mean, your argument's really, I think, based on the language used in certain communications. If you're looking at reality, this committee established by the association plainly has considerable limitations on its ability to ascertain the objective facts. It can do its best, but its conclusions are not going to be authoritative, and they won't necessarily be the same as those which a tribunal with the powers of a tribunal would reach.
Well, we submit that their conclusions will attract a considerable amount of respect and authority given what the respondent is and who its members are. I mean, I take your Lordship's point that the respondent can't can't summon witnesses, for example, but there's no reason why it can't interview witnesses. That's within its, well, that is something that it could lawfully do. There's no reason why it couldn't take witness statements from those witnesses. There's an awful lot that the respondent could do as part of a formal investigation, which would be, we would submit, fall into a very different category to what the media might do in the course of an inquiry.
Is the real concern here that the association may publish the results of its inquiries, and because of the respect in which that body is held, that would have a damaging effect on the Chief Justice?
Well, certainly we assume that the respondent will publish its investigation. It's published everything else so far, and has answered questions to the media in relation to issues that have arisen.
What would
So-
the position be in relation to the law of defamation? Would it be covered by qualified privilege if it were this body, whereas the other reports might not be?
Maybe that's not something I've considered at any... arguable, I suppose, it would be the answer.
And clearly, so long as the matter remains internal to its members, there would be a common interest in it, and so a qualified privilege.
Yes.
But that wouldn't, I'd have thought, be the same if it were to tell the general public.
Well, I'm going to come in a moment to what we say would be the wholly undesirable consequences of the respondent's investigation concluding that the allegations were proved. And that's, I think, almost the next item on my agenda. So can I just conclude why I say that there is a distinction to be drawn between the respondent's investigation on the one hand and an investigation by the media on the other hand. I think I've got to the fifth point, which is that the respondent's investigation closely mirrors the Section 137 tribunal investigation. I appreciate my Lord Reed's point that it doesn't have all the powers in terms of summoning witnesses and so on that tribunal will have, but it doesn't fall very far short of that. And then finally, the respondent's investigation we submit has the potential first to mislead the public as to the respondent's role in the process of investigating a judge, and or as to the weight to be attached to and the significance of its findings because of what the respondent is, who they are. Secondly, the potential to make the task of the tribunal much more difficult, and I'm going to put some flesh on those bare bones in a moment. And thirdly, it has the potential to undermine public confidence in the Section 137 process, particularly if the tribunal were to come to a different conclusion on the facts to the respondent. So let me then consider the consequences were the respondent to find that the allegations were true. First, their findings, we've assumed, will be published and will inevitably attract a widespread and intense media coverage. Secondly, they're likely to command considerable respect, as I say, given what the respondent is and who it comprises, and given that one of the members of the investigating committee is the respondent's president. So there are likely, therefore, to be many members of the public who will accept their findings and who will say to themselves, well, there it is, the Law Association has investigated these allegations, they found them to be true, that's it, matter closed. Thirdly, there may well be enormous pressure from the media and no doubt from members of Parliament, former judges, members of the public, no doubt members of the Respondents' Association, if not the respondent itself, on the Chief Justice to resign. In short, he may be driven out of office as a result of the findings of what we say is the respondent's unauthorised investigation. And that's not, we submit, how judges should be removed from office. Fourth, if the Prime Minister were to decide to trigger the Section 137 procedure, the fact that the respondent has already carried out its own investigation and found that the allegations are true will make the task of the Section 137 tribunal, we suggest, much more difficult. Firstly, it will have to carry out its investigation against the backdrop of the respondent's prior investigation. Secondly, some witnesses may already have had the chance to rehearse their evidence or hear what other witnesses say, or may have had the opportunity to paper over cracks in their evidence revealed by the respondent's investigation. And finally, the tribunal may itself feel obliged if its conclusions are different, to justify why it has come to a different conclusion to the one arrived at by the respondent. Next, we say that such a finding by the respondent can, as Justice of Appeal Beverer accepted, damage the reputation of the judiciary, specifically in the present case, the office of the Chief Justice, especially if arrived at by a body such as the respondent. Indeed, we submit that it would be likely to do so. And then finally, we submit that such a finding will inevitably damage the reputation of the Chief Justice himself, and indeed the reputations of any other judges investigated by the respondent in this way, and will do so in a way that could never properly be reversed were the Section 137 procedure to be triggered and were the tribunal then to reject the allegations. Indeed, if the judge in question has resigned in the meantime, the Section 137 procedure may have been effectively overtaken by events. So it's for all those reasons that we submit that, as a matter of reality, it is highly undesirable in any event that the respondent should carry out its investigation. But our prior submission, of course, is that on a proper construction of Section 137 of the Constitution, its investigation, formal investigation to determine whether the facts are true or not and whether the allegations are true or not, is unlawful. Lady and Lords, those are our submissions on the Section 137 issue. Can I then turn to the VARIS issue that arises under the Law Profession Act? Can I make three preliminary observations? Firstly, I'm told by Mr. Jeremy that prior to the LPA, the 1986 Act with which we're concerned, when the legal profession in Trinidad and Tobago was fused, prior to that Act, neither barristers nor solicitors had any express power in the relevant legislation that applied to them to investigate a judge. Secondly, the Act with which you're concerned, the 1986 Act, was enacted in order to reorganise, for which read fuse, and regulate the legal profession in Trinidad and Tobago, as we'll see when we look at the long title in a moment. And thirdly, of course, as a creature of statute, the respondent's powers must be located fair and square within the statute. So with those preliminary observations, can I take you back to Volume 1 of the Authorities and go to tab 3 at page 1459. Where we see the Legal Profession Act 1986. Can you, if you'd be good enough to go first, please, to 1465, where you'll find the long title, which of course can be used as an aid to construction. An act to provide for the reorganisation and regulation of the legal profession, for the qualification, enrolment and discipline of its members, and for other matters relating thereto. If you go over the page to 1467, subsection 3 establishes the respondent body. Subsection 4 provides for its affairs to be managed and its functions performed by its council. Section 5 sets out the purposes of the association and the relevant purposes for present purposes are over the page. Although, can I just ask you to glance through little a to little e. I won't read them out to your lordships and my lady, but if you could just glance through them to see what they're addressed to in terms. And then over the page at little f, to promote, maintain and support the administration of justice and the rule of law. And then G, to do such other things as are incidental or conducive to the achievement of the purposes set out at A to F. 6 and 7 deals with practitioner members and non-practitioner members, honorary members at section 8, privileges of membership at section 9, expulsion and suspension and rights and privileges in section 10, termination of membership section 11, annual subscription section 12. And then I can take the rest quite shortly. If you would go please to 1470, part 3. Part 3 addresses membership of the legal profession, enrolment, admission and status. Part 4, beginning at 1480, addresses professional practice and conduct. And can I ask you to note at 1481, section 35.1, the rules contained in the Code of Ethics set out in the third schedule shall regulate the professional practice, etiquette, conduct and discipline of attorneys at law. Part 5 at 1488 is addressed to remuneration. Part 6, 1492, is addressed to the compensation fund. Part 7, 1496, miscellaneous provisions. Part 8, same page, transitional provisions. The first schedule, beginning at 1498, provides for the functions and the membership and so on of the Council of the Law Association. And then I should show you, your lordships and my lady, page 1509, which is part of the third schedule, which begins at 1504, setting out the Code of Ethics, and at 1509, paragraph 36, subparagraph 4, where there is ground for complaint against a judge or magistrate, an attorney at law may make representation to the proper authorities, and in such cases the attorney at law shall be protected. So, my lady and my lords, we submit, and this is unlikely to be contentious, that there's obviously no express power granted to the respondent under the Act to carry out this investigation. And we submit that if Parliament had intended that the respondent should have such a power, it would have provided for it expressly. Secondly, we submit that construed in the context of the Act as a whole, and having regard to its objectives as set out in the long title, Section 5, particularly page 1468, Section 5F and G, to promote, maintain and support the administration of justice and the rule of law, and to do such other things as are incidental or conducive to the achievement of that purpose. It cannot be construed as giving the respondent such a power. We say it cannot sensibly be suggested that Parliament can have intended that the respondent should have a power to conduct a prior, but in many ways parallel investigation to the investigation to be carried out under Section 137. My lords and my lady, there is no authority which supports the respondent's construction of Section 5 as entitling it to investigate whether these allegations are true or not. There is authority, and your lordships and my lady have seen it, in both the Mirabuck's case and the Chief Justice of Gibraltar case, that a body such as the respondent has authority, has power to make a complaint to the Prime Minister or the Governor General, whoever it is under the relevant constitutional provisions, a complaint is to be made. And we've accepted that a body such as the respondent may inquire into the facts sufficiently to determine whether there is a sound basis for making any such complaint. But there's no authority that provides that a body such as the respondent can go any further than that under its powers under Section 5. Indeed, we submit that far from such a power being likely to, and I pick up the words of Section 5 little f, to promote, maintain or support the administration of justice and the rule of law, it's much more likely that the respondent's investigation will undermine the administration of justice and the rule of law to some extent, or to a considerable extent, for the reasons I've already explained. But can I just summarise them for the purposes of the Vari's argument? Firstly, we suggest a duplicate investigation is by definition likely to do so. Secondly, such an investigation lacks any procedural safeguards. Thirdly, there's no guarantee of fairness or due process. Fourthly, such an investigation has the potential to mislead the public by leading them to believe that the investigation is in some way authorised. And then finally, it has the potential to undermine the public perception of justice being done in accordance with the Constitution. So for all those reasons, we submit that the respondent's investigation into whether these allegations are true or not is ultra vires its powers under the 1986 Act. Lady and my Lord, thanks in no small part to the relevant paucity of interventions from your side, that completes my submissions on the first two issues in the case. And Mr. Benjamin now has rather more time than he was expecting, I think, to address you on the issues of natural justice and apparent bias, unless, of course, I can assist you any further on those first two issues.
Well, we never mind if people take shorter time than they anticipate.
I've discovered
You've
that.
discovered that,
Yes,
have you not, Mr. Hayes?
Yes.
And no doubt Mr. Benjamin will discover the same.
No wonder he will bear that very much in mind.
Yes. Thank you very much.
Thank you.
My lady, I will bear that in mind, that to favour brevity. My lady, can I make
It's
some...
entirely up to you, Mr. Benjamin, what you do.
And I'm grateful for that indication. Can I make some preliminary observations as a segue into the detail of my submissions? The Chief Justice respectfully submits that fairness in the context of the conduct of the Law Association is applicable, however it is characterized. This is because the association has already embarked upon an exercise of, and I use quotation marks, consultation with the Chief Justice. Secondly, it is also because the association has publicly undertaken to observe due process, and I will take you to the public statement where they say so, dated the 18th of December 2017. The association thereby has generated on the part of the public the expectation, and a legitimate one at that due process will be observed. Fourthly, there are repercussions for public confidence and the judiciary and the Chief Justice that all demand the observance of such due process. Fifthly, due process, without recourse to authority, entails an objective and impartial course of conduct, subject to the twin obligations of procedural fairness and freedom from, and subject to the obligation to be free from apparent bias. these two requirements apply to the actual conduct of the law association and not as a result of its belated characterization or recharacterization as set out in its case. The Chief Justice finally respectfully submits that the law association has breached the rules of procedural fairness and has not complied with the obligation to avoid apparent bias in the manner complained of and the details that I will come to in a moment. Of necessity, although these two requirements are seen and often analyzed in the case law separately, we respectfully submit that the association's conduct is to be taken as a whole, and therefore these two requirements together. The respondents in their written case make complaint that the Chief Justice is advancing a complaint of unfairness or breach of natural justice on the basis of three matters which they say are not sufficiently or at all adumbrated or given advance notice of in the Part 56 statement. Those three matters are: one, a lack of effective, appropriate and procedural safeguards not being provided to the Chief Justice; two, a failure to provide the Chief Justice with all the material available to its investigating committee, that is to say the Committee of the Law Association; and three, the failure to provide to the Chief Justice a copy of either its interim or final report and an opportunity to comment upon it. We do not know which that is because they have not disclosed the current state of affairs in their affidavit material. We say, and we invite my lords and my lady and my lords, to go first of all in relation to those complaints to the Part 56 statement. Can I invite your attention first of all to Volume 1, and it's to be found at pages, electronic bundle numbering 11 to 29. The substance of it begins at page 12. And as for the first of those complaints, which the association says, we say inaccurately, are not to be found in the Part 56 statement, can I invite your attention to page 25 of the electronic bundle, paragraph 22, and I quote, does Lady have it? The LAT's letter, and this is a reference to the letter dated the 20th of January 2018, referred to in the previous paragraph, paragraph 21. The association's letter did not disclose the process or procedures that had been adopted by the committee or the advice that the committee had received, nor did it disclose any reports to the applicant. So we say in a clear standalone paragraph, the first and third of the complaints, that is to say that there's an attempt by the Chief Justice to expand factual bases for his judicial review application. It's contradicted by the language to be found at paragraph 22. In support of that, might I invite my lady's attention to page 35. Page 35 is the Chief Justice's affidavit. It's in the following pages. I'm inviting my lady and my lords to look at paragraph 12, and where you will see in identical language the observation of the Chief Justice that the letter of the 20th of January did not disclose to the Chief Justice the processes and procedures that had been adopted by the committee or the advice that it had received or any reports relied upon. Taking it slightly out of order, can I ask my lady to go back now to page 15? because I've given you instances, there are others, but I've given you 2 instances where the first and the third of the complaints are dealt with. Can I now treat with the second complaint, which is the failure to provide material? Can I invite my lady's attention to paragraph 15? And if we could pick it up in the middle of the paragraph, so the second full sentence beginning with the words, further, the association's inquiry and/or investigation. The association's inquiry and investigation is being conducted in bad faith and in breach of the rules and requirements of natural justice. In that, in conducting the said inquiry and/or investigation, the association has not provided, except on demand from the applicant's attorneys, copies to the applicant of the material which the association and/or its committee established to do so has been or is considering. And then a repetition of the other point about reports, and the association has not undertaken to provide to the applicant a copy of its committee's report, which the association is threatening to submit, etc., etc. So we say respectfully that the complaints set out in their case, beginning at paragraph 107 onwards, as a chapeau to the discussion that they advance on the right of natural justice on the one hand and apparent bias on the other, that those 2 complaints are not supported by what is to be found respectfully in the Part 56 statement. Can I move now, my lady, to the substance of my submissions on apparent bias, to be followed by the same in relation to natural justice? Oh, I'm sorry, there is one other issue that I should mention. In relation to apparent bias, there is a complaint on the part of the association that it is not open to the Chief Justice to rely upon the association's press release dated the 14th of December, 2017. That is the press release in which they describe the Chief Justice's conduct as reckless. Now, there is no issue between the parties as to the fact that that release is in evidence. And if I could just give you one indication of where it's to be found, can I invite my ladies and my lords' attention to page 23 of the electronic bundle?
Mr. Benjamin, this
lord.
business about reckless,
Yes.
does it need to be put in context?
Yes.
Am I wrong to have picked up that the association was saying that what was reckless was your client's alleged failure to respond to all the things that were being said in the press?
My lord is right, and I'd like to make some observations on that.
Very well.
And can I now, in order to do that, can I, while very quickly invite you to look at paragraph 23
Certainly.
for its basis, and you will see at paragraph C, the report in the Daily Express of the 15th of December, which is, of course, the day afterwards, and I trust my lady and my lord see that, and that there was a short excerpt by way of a quotation from the press release. It is more helpful, I think, my Lord Wilson, to look at the actual press release.
Certainly.
You will find that at page 43. And my Lord, I'm going to make 2 submissions. One is going to be about textual context, and I'm going to express limited agreement with my Lord's observation. And then I'm going to make a broader submission of the broader context, if my Lord will bear with me. My Lords and my Lady, I'm not going to read this to you. Can I just ask you to read it to yourselves?
Well, I think we've all read it.
Of course you have read. I apologize, sir. Can I? Lady Mayor? Yes, good. My Lady, my Lord Wilson is right to say that as of this date of the writing of the press release, His Lordship had not responded. He did so the next day, on the 15th of December. It's quite important to get that. And so the association is saying, and I just read 2 sentences, the last sentence of the first paragraph, they refer to, and I quote, the Chief Justice's steadfast refusal to refute these and other accusations leveled against him is unacceptable and incomprehensible. And then at the very next paragraph, the council is of the view that the Chief Justice's continued failure to challenge the allegations has the potential to irreparably bring the office of Chief Justice into disrepute and, by extension, tarnish the entire judiciary. His continued silence is nothing short of reckless. So my Lord is right, the narrow textual context is up to that moment in time. There was no response. As it happened, it was being drafted at the same time and it was published the next day. The broader context is as follows. By this time, the Law Association has already done the following things, and you've already had this drawn to your attention by Mr. Havers, but it's helpful. The first is that they've gone to see the Chief Justice and they have told him that they are going to embark upon an investigation. And I'm going to resist the temptation to characterize that one way or the other, because my little friend Mr. Havers has done that already. Secondly, they have communicated that fact not just to the body of the profession, but to the entire country. And so we say, in that context, having embarked or having announced the embarkation or the commencement, and we don't know when they did what, so we are slightly in the dark, that with this kind of statement was not restrained, was not modest, and that's the language we'll come to momentarily when we come to look at their response or their defense of the allegation of bias, of apparent bias. And that it really reflected a degree of impatience and irritation on the part of the association, because to be fair to them, there had been an earlier statement issued by them in which they had called upon the Chief Justice to make a response. And they were not satisfied with his timing.
That I think had been a month earlier.
Correct, my Lord. My Lord Reid, yes. It's a month earlier, I think on the 14th of November, 2017. But we say that it's either one or the other. If the association felt entitled to publicly rebuke the Chief Justice, as they did, and to do so in such unqualified terms, then that would have been acceptable if there were no publicly announced investigation. Conversely, if the association, having publicly announced its investigation into the allegations made against the Chief Justice, then what was required of it was restrained silence, publicly so. Without getting ahead of myself, if I can contrast it with the public statement made by the auditor in Porter and McGill, without inviting my lady and my lords to look at the case just yet. I will come back to certain passages in it. My lady and my lords will recall that in Porter and McGill, there was criticism of the press conference held by the auditor, but even he was doing it at a time simultaneously with letting the subjects of his investigation know that there were provisional findings against them. This was at a time before any statement of any findings or any indication. As a matter of fact, at this stage, it is not even clear that the association has spoken to anyone. So before the match starts, as it were, the association is entering into the public debate. Now, they make it very clear, perfectly validly, that these allegations are in the public domain. But it's not for the association, we say, in accordance with the obligations of procedural fairness, and importantly, ensuring that there is public confidence in their process. Pausing there, I am not interested in outcome yet, in fact at all, in my submissions. There must be public confidence in a publicly announced process. and you undermine that public confidence if you fail to resist the temptation to make public utterances of this nature. Because if you go over, and I invite my lady and my lords to do so now, if you go over to the next page, page 45, you will see that immediately this statement enters into the public domain. Now, my lady asked my learned friend, Mr. Havers, a question about defamation. My lady and my lords are well aware that there is a line of authority which says, even though the ordinary person only reads the headline, often we do that, we read the headline, we read the first paragraph. So when you are analyzing and assessing, to use my Lord Reed's word, the realities of the situation, then the moment you issue this kind of public statement, you know it is entering into the public domain while you are conducting your investigation. And we say that is a bridge too far. You need to look at it. You don't need to read any of the text. Reckless behavior. But my Lord, I take what you say about the textual context. It is unlikely that the ordinary member of the public is going to have a copy of the press release to read alongside the headline. I'm not pretending for a moment that there isn't other text there. That's not the point I'm on. I'm really on public perception, which of course is the touchstone for the test in Porter and McGill, and as my lady and my lords are well aware. Now, in the course of correspondence with the association, and if my lords and my lady remembers the sequence in broad outline, there was an announcement on the 30th of November. This is taken from the Statement of Facts and Issues. The very first time that there is a formal engagement with the Chief Justice in writing after that meeting on the 30th of November is the 20th of January 2018. So by then, some 7 weeks have passed. And these are the kinds of statements that are, let me be fair. This sort of statement is entered into the public domain coming from the Law Association. In answer to the letter of the 20th of January, can I invite my lady and my lord's attention to his response? It's page 62 of the electronic bundle. And I'm going to invite you specifically, my lady, because you're working electronically, to page 63. And so this is to deal with the suggestion, on the evidence as it were, that there was no complaint about process or procedure. If I can take you to the 1, 2, 3, 4th paragraph, my lady will see it at the very top there, top 1/3. In your letter, meaning the letter of the 20th of January 2018, you do not specifically identify any process or procedure designed to ensure impartiality and fairness and due process. So that's what we say there. We specifically put them on terms. You've written to us. We've been reading about your process in the newspapers. You do not have the courtesy to write to us before the 20th of January 2018. You've given a number of public statements and press releases, and this is our response. Well, how are you going to go about doing this, and what are you going to be doing that is going to ensure fairness? And we say at the end of the letter, the very last paragraph, the very last second sentence in that paragraph, my lady, we say that the association must support the application of due process and impartiality and uphold the independence of the judiciary at every juncture that requires that no judge, whether Chief Justice or not, and pause in there because it's actually not about us, we happen to be the applicant, should be removed from office without good cause and with the question of removal being determined by an independent and impartial tribunal. So whatever they say they are doing, we say with respect, they are under the obligation, and we've said it to them, to be impartial. Can I invite your attention further to page 72, electronic numbering. Now, just by way of context, before I take you to that paragraph, there has been a further exchange of letters. You will see that on page 66. And over the page, in that letter of the 31st of January, we've asked them for some WhatsApp messages and photographs on the basis that we have already complained to the newspapers, the pre-action protocol letter alleging defamation, that those WhatsApp messages and photographs have been fabricated. So we asked the association, please provide to us, in that context, page 66, copies of those documents, WhatsApp messages, etc. At page 69, they are provided, and I don't need to take you to them, and that's done by letter dated the 6th of February 2018. And the following week, we write to them to say, we complain about the withholding of that material, because we say they could have provided it by the 20th. We say it was plainly wrong. But importantly, at the very end of the letter, we say, you are not, that is the letter of the 6th of February, you do not acknowledge our significant concerns about fairness raised in our letters dated the 30th and 31st of January. Nor do they acknowledge, we say, the substantive responses set out in the annexures to our letter of the 30th of January 2018. And although I didn't propose to take you to it, that annexure is a bundle of the pre-action protocol letters we sent to the press in which we made an unqualified denial of the allegations made against us in the press as far as we understood them. Now, it's important, respectfully, we say in this context, to see what the response of the association was. Can I invite you to look at the response of the association, which is to be found at page 650, around this time. First of all, by email. So I'm in volume 2, 650, electronic numbering. And you will see there that a trust lady has it, that Mr. Mendez is acknowledging receipt by email of the letter dated the 31st of January that I just invited your attention to. And my lady and my lord sees that there's an exchange of correspondence. And the reference to the letter dated the 5th of January 2018, does my lord have it? Page 650. My lord Wilson? The reference there to the letter of the 5th of January 2018 to O.R.T.T. Lida. She is the editor of the Express, which is attached. And he says then that the committee will now proceed to finalize its report, which will be submitted to Dr. Francis Alexis QC and Mr. Eamon Courtney for their advice. So what's happening there is they've written to us for the first time on the 20th of January. We've written back on the 30th of January saying, well, provide us with some information. Oh, sorry, the 31st of January, provide us with some information. And they are indicating to us immediately that they are intending to proceed to finalize their report, without giving us any opportunity either to say anything about the matters about which we're complaining, that is to say, the procedures, or the material, or an interim report on the assumption that by this time that there is one.
But you had been told, I think, on the 20th of January, what the matters, in some detail, about what the matters were, and the Chief Justice was invited to give his response.
Absolutely, my Lord, and I rely on that. And can I pick it up there? And I say, my Lord will recall that I made a submission about partial engagement, partial consultation process, so that their focus is, please answer our questions, and they identify the questions. They disregard what we would say is our legitimate inquiries. Well, what's the process? How are you going to be doing this? And they also disregard our further legitimate inquiries about, well, what material do you have? You provided us with some, because we asked a very specific question, my Lord Reed, yes. We asked a specific question because we had a specific concern about fabricated documents. And they provided those, and those alone. What they haven't provided us with, and there is no indication that they propose to provide us with, a copy of any provisional interim or final report.
What material is there that suggests that they had more?
There are a number of public statements given by them over the period of November 30th to January 20th, which suggests that they are and have been speaking to certain persons. So if by way of example, if I can invite my Lord, this is just an illustration. If I can invite my Lord's attention to volume 2, page 645. And I apologize, the quality of the print is very difficult to engage with. And my Lord, I'm going to refer to this for two purposes, but can I answer my Lord Thompson's question first? What indication is there that there is other material? So this public statement, under the heading, Law Body Adopts Cautious Approach, I trust my lady has it, begins as follows. The Law Association says it will await the outcome of the work of a committee set up last week to look into and verify allegations made against the Chief Justice. I think Mr. Havers read the first part of this. So can I go to the part that has not been read? So that's paragraph 1 and paragraph 2. As part of due process of the law, he said, the committee will also give the Chief Justice an opportunity to be heard, but could not say whether this would be done by a face-to-face interview or questions sent to the Chief Justice for his response. Reminded that the Chief Justice appears to take a long time to respond to questions, as happened during the Marcia Air Caesars issue, he said we have no control over how long he takes to respond. Last Thursday, the Council of the Association met, indicating its own increasing alarm at the allegations. Next paragraph, it expressed particular concern in the allegation that he intervened. Last Friday, the Chief Justice issued a response to the allegations, and so on. Asked for his views on response. So I asked his view, I'm on to the penultimate paragraph, on the responses of the Chief Justice, especially in light of his admission to forwarding the names of people for public housing. Mr. Mendes says, we will see what will come out of that. And then he closes by saying, based on the findings of the committee, he said, the council will then decide what its next step is. So, my Lord Thompson, we know from the contents of the letter dated the 20th of January, if I could invite my Lord's attention back to that they had made specific inquiries of certain named persons set out in that letter. That letter is to be found at IA 9 and at page 58, 59, and 60. So that if you bear in mind, again, in answer to my Lord's question, that what we have been provided with in answer to our queries were WhatsApp messages and photographs and so on. But when you look at the specifics of paragraph 4 and 5, you will see that they have spoken to, we don't know how they've done it, or on what basis, or in what manner, specific named persons. So they identify specific individuals. At paragraph 4, is my Lord with me on page 59, they say that he made follow-up recommendations with WhatsApp messages and personal calls to a senior HEC manager whose identity has not been disclosed. Over the page at subparagraph 8, they say that he caused his friend or acquaintance, Mr. Edwards, to contact the manager and so on. So, my Lord, that demonstrates that they have made inquiries of the HTC or some of the individuals there, that there is other material that they have gathered, but none of this material, none of it has been provided to us. None of the basis of it, none of the, in other words, yes, they have said, my Lord Reed, who the individuals that they've spoken to, but none of the supporting or underlying material has been provided. My Lady, respectfully, our submissions as to as to bias are as follows. We say that the applicable law makes clear that it is contextual. That is to say, the application of the observation of the rules of natural justice and the applicability of the obligation to ensure that you are not tainted from bias is derived from the context. The context here is that the association must be required to embark upon an impartial process, and that the association is wrong to say that they are not bound by the strictures of Porter and McGill simply because the association is not making decisions about our civil rights and obligations. We say that even in the context of, by way of analogy, an inquiry, that is to say a public inquiry, where the commissioners or the tribunal of the inquiry are specifically not empowered to make decisions dispositive or determinative of specific rights and obligations, that even in those circumstances that there is an obligation to observe the requirements of impartiality and fairness. And can I make good that suggestion by inviting your attention to one loose copy, I don't know if it's on your benches yet. It's a decision that we provided only this morning. It's a decision of this court. It's Mitchell and Georges.
Can I just ask you, just
Yes,
for a piece of information,
Yes.
in relation to the letter you took us to a moment ago,
Yes,
at pages 58 to 60,
yes,
I'm just wondering, on page 58, the first numbered paragraph
yes,
gives some information about a fraud of which Mr. Romano had been convicted, in which essentially he was promising that through his friendship with the Chief Justice would be able to assist people to obtain housing.
yes.
It seems to be the essence of it. I'm just wondering, do the allegations about housing in paragraph 4 and the various individuals who are said to have been recommended, does that go beyond the evidence that came out at the trial?
Well, Lord, we have no way of knowing the answer to that question. In other words, we have no information, and none has been provided to us about any specifics of a trial or the specifics of a conviction, other than what's contained in the newspaper. We do not know what the association has. Yeah. So
I see.
I'm not in a position to specifically criticize or complain about something that has not been provided to me. We simply don't know. We simply don't know. We would like to know, but we haven't had the benefit or the advantage of being informed.
Thank you.
My lady, this is a decision of my Lord's board, my lady's board. The speech was given by Lord Clark. I rely on it only for the adumbration of the relevant principles to be found in paragraphs 8 and 11. I don't propose to read them to you. If I can ask you to just read them very quickly, and then I'll make a brief submission on it. So we say that this court has already established as authority that in the context of an inquiry where no one is making decisions about specific rights and obligations of an individual who is the subject of inquiry, the applicable test of Porter and McGill applies, and the requirement of impartiality obtains, and that the association is wrong to suggest otherwise. Wrong in law and wrong in fact. We say further that the arrangements, such as they are, and this is hence the complaint about what are the procedural safeguards, do not reveal or demonstrate for the benefit of the public that the association's machinery is independent. I've already addressed you on the requirement of impartiality. We say that what is important is that the processes, whatever they are, must present an appearance of independence to the public. And I make good that suggestion by relying upon a second authority, and I promise you this will be the last from the bench. This is the case of Gillies against Secretary of State for Work and Pensions.
Thank you, Mr. Randall.
And while the whole of the judgment repairs rereading, can I be forgiven for taking a shortcut and inviting my lady to look at my lady's judgment, beginning at paragraphs 38 to 40. And again, I will not read it to you in view of the passage of time.
This was about having medical.
Absolutely, my lady. That was a
Members
case
of a
involving tribunals, and my lady began her judgment by expressing a particular interest in the work of tribunals. I rely upon it for the helpful analysis and the relationship between independence and impartiality to be found at the beginning of paragraph 38. And I was simply making good the submission that I am advancing, that there's a requirement both of impartiality and that it is important that the arrangements present to the public the appearance of independence. And that then, borrowing my lady's words, that's the, as it were, the framework which must be secured by the Law Association in the minds of the public because it is their perception that matters. I think it goes without saying that as far as impartiality is concerned, well, that of course is simply that justice must be done, but it must also seem to be done. And we say that analogies, respectfully, advanced by the association with a private prosecutor, as they do at paragraph 131 of their written case, where what you are doing is looking at the conduct of the association by reference to not only is it a potential complainant on its own evidence, it's a spokesperson, and the evidence on that is legion, and I think uncontrovertible, but it is conducting the investigation by way of its committee. Further, its investigating committee reports to its counsel. Both the committee and the council are presided over by the president. And yet further, they propose, whenever they get to the point of a final conclusion or report, that that report will be presented to the body in general meeting, presumably to be presided over by the same president. So that what the structure represents is a lack of safeguards. There are no checks and balances, such as you might think would be appropriate and such as exist under the Constitutional Reform Act of 2005 and the Scottish equivalents, all of which are to be found in the bundles of authorities. We say that the conduct of the association demonstrates that while the president was giving regular updates to members of the media, and he says, to be fair to him in his affidavit, I was merely responding to queries from them, we were not the benefit of such updates. There was no communication written communication at all prior to the 20th of January 2018. We say respectfully that it is the association which has given members of the public the distinct impression that its work will be final. And we say that in answer to some of the points raised by my friends in their written case, And if I can take you to that now. Can I invite my lady and my lord's attention to paragraph 137 of the respondent's written case? Page 1323, my lady, I apologize.
Thank you. Yes?
Yes. At paragraph 137, the association sets out 8 preliminary matters, which it says are derived from the text, and then goes on at paragraph 138 to say, identify what it says are the facts that the fair-minded and reasonably informed observer will be aware of. So I'd like to deal with those, if I may.
Well, you haven't got a lot longer, Mr. Benjamin.
I'll do the best I can at the time available to me. So, as to one, we say, that is the A, we say that they say that the previous motion of no confidence had nothing to do with the allegations that are the subject of inquiry. But the evidence discloses, and I can only give you the page reference, that at page 594 in Mr. Mendes' affidavit, he makes the point that the Chief Justice did not raise any questions about the power of the association to inquire then in relation to the other issue. And so he's relying upon the response of the Chief Justice in answer to the suggestion made by them, whereas it is clear that both the motion of no confidence presided over by the President the year previous, as well as the meeting to come, give rise to a serious apprehension of prejudgment on the part of the association, taken together with its public statement, even in its context of reckless and the like. At points B and C, we say respectfully that the association is relying on distinctions that are meaningless. There is an attempt to make a distinction between the council on the one hand and a vote of the association in general meeting. While those are correctly, procedurally valid distinctions, what matters is what is the perception on the part of the public. That is to say, they would regard an identity of purpose and person as far as the law association is concerned. So that takes care of those two matters. D is uncontroversial because it's a repetition of what's to be found in the Act. The E and F is merely a repetition of the fact that the allegations are already in the public domain. What we say is of paramount importance is the obligation on the part of the association to ensure that all of the safeguards are in place and that they act entirely impartially and entirely free of bias. We say that their position that they are not obliged either to observe the rules of natural justice or free from the Porter and McGill obligations is entirely inconsistent with the statutory mandate. We say it's inconsistent with their obligation to uphold the rule of law, that they could possibly be free of those obligations, however modified to meet the particular circumstances. And we say that that is made even stronger by the fact that they have already embarked upon that process. At paragraph F, we say that the association is wrong to disregard the denials of the Chief Justice, whether to be found in his pre-action protocol letter of the 5th of January, 2018, or in his earlier public statement of December the 15th, 2017. We say that G and H, G doesn't take the matter any further. H simply sets out part of the narrative. I is really a question of timing. but we say that nothing that is said by the association in any of these paragraphs explains their silence between the 30th of November and the 20th of January. We say that in relation to their reliance upon their so-called obligation to inquire, that's a matter of law for this board to decide, and they're not entitled to pull themselves up by their own bootstraps. We say that in any event, the hiring of, I'm on letter M now.
Well, you're out of time.
I'm obliged, my lady.
I'm afraid.
In that case,
but I think we understand what you'd say about it.
I'm deeply obliged, my lady. My lady, would you permit me a closing comment by way of peroration?
One sentence.
One sentence. Respectfully, the Chief Justice's case is simply that when the association's conduct of its investigation is taken as a whole, it has not treated him with complete fairness. Partial fairness doesn't cut it. And further, it has defeated the public's legitimate expectation that that is exactly what they would do, not the least of which is because that's what the association told the public it was going to do on December 18th, 2017. My lady, those are my submissions. I apologize for going over by a minute or so.
Worry not. You have summed them up very cleverly, if I may say so, in a single sentence. Well done. Thank you. Well, we will now adjourn and look forward to recommencing at 2 o'clock.